Seeing some familiar faces.
Morning, Wassim.
Morning, man.
Hi, Al. Hi, Jess.
Hi, Jasper. Hi.
Morning.
I don't see Brian, but I hear him. Are you traveling incognito today, Brian?
No, it shows that my video's on.
It can't see it, Brian. Is there a screen
Hold on.
blocked or something? Not that we need to see it, but it's always nice to see it.
Yeah, I don't know what's going on here because as I said, it shows my video being on.
It's all black.
Do you
I
have
mean,
something
it's just
up
like a
on the camera?
black blank screen.
It means your system is set for the wrong camera.
Zine, do you have any advice for Brian? Oh, we're getting on.
There he is.
Oh,
See him.
my.
Nice
Turn
beard.
the video off.
So do you think we're going to do baseball arbitration again, Brian? I mean, is there going to, God knows what's going to happen.
A little concerned about this panel, given that Wassim is on it.
Well, you can take, well, do you want us to put you in a breakout room? We'll put you in the hallway and,
You mean talking about Wassim?
yeah, you can, you two can have it out, I know. We'll give a couple more minutes and then we can start.
Hi, Alan.
Hi. Who said that?
How many? This
Morning, Bill.
Hey, Alan. How are you?
Nice to see you.
Nice
I'm
to see
gonna
you.
mute. I'm gonna mute the participants. Give it 2 more minutes and then we'll start.
William, I think you need a haircut.
He's muted. He can't respond to that.
Perfect.
I'm gonna mute you so you can't pick on people, Brian.
Otherwise, he'll have to unmute William.
Oh, I did. So what did you say? Like my haircut?
He didn't. He didn't. I like it, though.
I think barbershops are opening soon. But that nail salon that opened in Kingston turned out not to be a good idea. Holy mackerel.
Yeah.
It's terrible. I'm trying to mute you, Bill. Let me mute you. Okay. I think we're going to begin. I think people are still kind of rolling in, but let's get going. First of all, welcome to a panel discussion on labor arbitration in the courts, very timely. And I want to also say thank you to everyone for joining us on a Saturday morning in summer. This conference is sponsored by the International Labor and Employment Relations Association, ILERA, the Canadian Industrial Relations Association, the National Association, and the GTA chapter, and the Center for Labor Management Relations at Ryerson University. Originally, this was an international conference that was going to be in person, bringing together hundreds of people from around the world. As it happened, COVID-19 had different ideas, and so we pivoted to a Zoom conference with the help of an awful lot of people acting behind the scenes. Before I introduce the panel, I'm just mentioning we have a facilitator, a student at the University of Toronto, Tasneem, and now you're out of my screen, Tasneem, so your last name is, I'm losing, but anyways, if we have any problems as this unfolds, we can ask Tasneem Omar Ava for her assistance, and she'll be hovering in the background. The topic that we're dealing with is what's happening with labor arbitration and the courts in light of some recent decisions in December 2019, Vavilov and Bell Canada. Over the last 20 years or so, labor arbitrators' purview has been expanding. We now deal routinely with discrimination, privacy claims, safety and health. We award damages, and along with our more expansive grounds, the courts have gradually been reducing their specific degree of oversight and providing a great deal of deference to the decisions of arbitrators. Deference pretty well is the default position. That changing with the recent decisions? To answer that question, we have three panel members who I'm going to briefly introduce in the order in which they'll be speaking. Dr. Pnina Alon-Shenker is a professor at Ryerson University with a joint appointment in the new Faculty of Law at Ryerson and the Ted Rogers School of Management. Her particular interests are in labor and employment law, with particular emphasis on workplace discrimination and diversity, and various forms of employee representation and voice. She's the co-editor-in-chief of the International Journal of Comparative Labor Law and Industrial Relations, and is a member of the Labor Law Casebook Group. Our second speaker is Wassim Garzouzi. He is a member of the Ottawa-based law firm of Rabin, Cameron, Ballentyne, and Yazbeck. He acts on behalf of unions in all matters related to labor relations, at arbitration panels, at labor boards, at courts, and other tribunals as is necessary. He has a variety of clients around Ontario, and he's a frequent visitor to all parts of Ontario and Quebec, if I understand correctly. He also is engaged in collective bargaining and in the federal and provincial sectors. Our third speaker is Richard Charney, who is the global head of employment and labor practice at Norton Rose Fullbright law firm. He practices on the management side, representing employer clients in labor relations and employment. He has a wide variety of federal and provincial clients. And he, again, like Wassim, represents his clients in arbitrations in front of all manner of employment and labor tribunals and in courts, including the Supreme Court of Canada. He also rolls up his sleeves and sits at bargaining tables on behalf of his clients from time to time. So we have panelists with broad academic and practical experience, and I will be moderating this panel. My name's Alan Ponak. I am a recovering academic and a practicing labor arbitrator in Ontario and Western Canada. So with that, let me, Tasneem, is there anything as the moderator that you need to tell our various participants, our audience?
Right. Yes. Yeah, I'll briefly go to a technical overview that may help everyone to figure out how to reach out to me for questions, so I can help them out when the time is there for questions, and also if there are any technical elements of the meeting. So I can briefly go through it. So first of all, welcome everyone to session D, expansion of labor arbitration and role of courts. And I'm Tasneem, and I'll help you out with the technical elements. And upon entry, you have all been muted, and we would advise you to stay that way throughout the session. When the time comes for a question, in between the presentations or at the end of presentation, you can use the raise hand feature at the bottom of the Zoom screen to ask your question. When you click on the participant list, a new window will appear, and you will see a blue raise hand button. And when you click on that, your name will appear at the top of the participant list. So Alan and I can recognize you from there, and you can ask the question. And at that point, you can also unmute yourself by clicking on the microphone icon at the bottom left of your Zoom screen. And I can also help you out with that when time comes. And throughout the session, if you need any assistance, you can reach out using the chat function. You can reach out to me or the chair with questions as well. For that, you can use the box provided to send your note, but make sure before sending the note, you change the audience from everyone to my name or Alan's name. And other than this, we would advise that please avoid using the chat function during the presentation, as it may be distracting for the presenters or the audience members. You can use the clap or thumbs up features from the reactions icon. And those of you who are joining us via phone, we would advise that you stay muted throughout the session. And when it is time for a question, you can simply speak up. And just for everyone's information, this session is being recorded and it will be placed on the YouTube channel of Canadian Industrial Relations Association. If anyone has any objection, then we can stop recording. And now I'd like to turn it over to Alan to start the session.
And although the chat function, I mean, you can also use the chat function to perhaps put up some questions, and I can check it from time to time. Let me start. Professor Alon-Shenker, the floor is yours.
Thank you. Thank you very much, Ellen, and thank you everyone for the introduction, for inviting me to participate in this panel. So I was asked to provide an overview that will set the stage for what I'm sure will be a fruitful and engaging discussion on what I see as two interrelated issues of judicial deference. First, the expansion of arbitral jurisdiction over matters that beyond the so-called four corners of the agreement, specifically as was formulated in the Weber and the Perry Sound decisions, but also the confusion and the critique that these cases and subsequent cases have raised. And second, the standard of judicial review applicable to grievance arbitration, which is guided by a very differential approach, but whether the decision, the recent decision in Vavilov represents a shift in this approach. So as we all know, the modern Canadian labor arbitration system was established during World War II, first with federal regulations in 1944 that was then repealed and replaced with provincial labor relations legislation, but still very much inform our laws today. And it was much influenced by the American Wagner Act, but with some important variations, including the rule of grievance arbitration, according to which during the term of a collective agreement, the parties cannot engage in a strikes or a lockout, and instead they are required to submit their differences arising out of the collective agreement to a neutral third party for grievance arbitration. And now, while labor arbitration in Canada generally is a statutorily mandated procedure for the resolution of disputes, it has always been understood as a private method for a dispute resolution between employers and unions representing employees. And private in the sense that the parties have significant control over the process, even to choose the arbitrator, but also private in the sense that this is an alternative dispute resolution, less formal, less costly than court litigation, and often less adversarial. So the idea was, and still is, that the parties would be able to continue to work cooperatively following arbitration, and that arbitration is final and binding. Now, challenges are possible, but would be relatively rare. And this has gradually begun to change since the 1970s in a process that was described by Bruce Argyplug as the procedural legalization and professionalization of arbitration. In short, as parties increasingly opt to use lawyers and arbitration awards as persuasive case law, as more complex legal arguments were made and decisions became lengthier, the process has inevitably become more expensive, slow, and sometimes more adversarial, to the point where some, like the former Chief Justice of Ontario, Warren Winkler, noted that labor arbitration has lost its course, its trajectory, its vision. And whether it's lost its course or not, grievance arbitration has certainly dramatically changed over the years. And it has been argued that several Supreme Court decisions contributed to this change by expanding the jurisdictional scope of labor arbitration beyond what was understood as the four corners of the collective agreement, particularly the Weber case in 1995 and the Perry Sound in 2003. In Weber, as we know, the employer hired a private detective who gained entry to the employee's house under a pretense and obtained some information that then was the base for suspension of the employee for abuse of sick benefits, and the employee and the union filed several grievances, but also the employee commenced court action seeking damages, alleging tort claims and charter's rights violation. And when his court action was dismissed for lack of jurisdiction, he appealed, and the Court of Appeal upheld the dismissal of the tort action, but allowed the charter claim, noting that it will be problematic to deny court access to individuals seeking protection of fundamental constitutional rights. But the Supreme Court held that both of the claims, the charter and the tort, fell within the exclusive jurisdiction of arbitrators and denied Weber access to the court. It ruled that arbitrators had exclusive jurisdiction over civil actions concerning common law and the charter, as long as the essential characters of the dispute arose expressly or inferentially from the collective agreement. And examples of that would be wrongful dismissal, bad faith on the part of the union, conspiracy, constructive dismissal, damages to reputation, and so forth. And the exclusive jurisdiction approach, the court explained in Weber, and I quote, satisfies the concern that the dispute resolution process should not be duplicated or undermined by concurrent actions. It confers to a pattern of growing judicial deference for the arbitration and grievance process and correlative restrictions on the rights of the parties to proceed with parallel or overlapping litigation in the court. And as you know, the decision in Weber has been heavily criticized. Michelle Peacher argued, for example, that the legal test of factual nature of the dispute and the ambit of the collective agreement, or the standard of dispute arising inferentially from the agreement, were vague, resulting in great uncertainty and inconsistency. Brian Etherington argued that in the name of efficiency and finality, Weber undermined substantive individual rights by closing access to the court on fundamental issues and subjecting the griever to the union's decision whether to proceed to arbitration or not, what Etherington named the Weber gap. Another concern was around the institutional capacity of arbitration to deal with tort or charter issues that were usually or typically litigated in court. And another concern was about whether it's appropriate that unions will deal with complex issues such as defamation, which might be very important to the individual, but may not serve the long-term interest of the parties in facilitating an effective dispute resolution. But this continues on in the decision in Parry Sound in 2003, when the court expanded the scope of arbitration even further. Here, a probationary employee was discharged after she returned from maternity leave, and she filed a grievance with the union, alleging the decision was discriminatory and violated various human rights code and employment standards act provisions. And it was interesting that her collective agreement stipulated that probationary employees could be terminated by the employer's sole discretion and was not subject to grievance and arbitration. So the issue was whether the arbitrator had jurisdiction over the discriminatory claim. And the Supreme Court held that the substantive rights and obligations of human rights legislation and other employment-related statutes are incorporated into each collective agreement over which arbitrators have jurisdiction, even in the absence of an express provision that prohibits the violation of a particular statutory right, as the laws establish a floor beneath the parties cannot contract. And any alleged violation of human rights or employment standards legislation constitutes an alleged violation of the collective agreement, which falls within the jurisdiction of the arbitrator, the Supreme Court says. And what type of jurisdiction? Is it exclusive or concurrent? It's not clear from Parry Sound. And this was sort of clarified a year later in 2004 in the Morin case as a concurrent jurisdiction. But we're still not sure about that. And this might depend on the statutory provision in the relevant province. And as we will probably talk about later in the Horrocks case, which is now in front of the Supreme Court. Now, the significance of the ruling in Parry Sound was that, and I quote, arbitrators not only have the power, but also the responsibility to implement and enforce substantive rights and obligations of human rights and other employment-related statutes, as they were part of the collective agreement, even if the agreement made no reference to them. And this includes health and safety legislation, privacy acts, workers' compensation, whistleblower protection, and employment standards. Now, subsequent decisions by the Supreme Court have tried to clarify those decisions and often added even more confusions. And I mentioned the Morin case in 2004. The Supreme Court clarified that Weber did not stand for the proposition that labor arbitration always have exclusive jurisdiction in employer-union disputes, depending on the governing legislation and the nature of the dispute viewed in its factual metrics. Other tribunals, said the court, may possess overlapping, concurrent, and even exclusive jurisdiction. And in that case, there was a group of young teachers disappointed by the process of negotiation and filed a discrimination complaint with the Quebec Human Rights Commission. And the issue was whether the tribunal should decline jurisdiction on the ground that the labor arbitrator possessed exclusive jurisdiction. And the Supreme Court held that based on the governing legislation in this situation, the tribunal had concurrent jurisdiction, and that the essence of the dispute was the process of negotiation, not a dispute which arises out of the operation of the collective agreement. The court explained also, interestingly, that the unions were opposing interest to the complainants, and that if the unions choose not to file a grievance before an arbitrator, the teachers will be left with no legal recourse. And further, even if the union had filed a grievance, the arbitrator would not have jurisdiction over all the parties to this dispute. And interestingly, these explanations were exactly what the Weber gap concern was all about. And indeed, Etherington suggested that maybe the Morin case was a turning point. after which courts will be more willing to consider not only efficiency and finality, but other considerations such as access to justice and institutional appropriateness. However, the trend is not very clear, and I'll give an example, the case of Bezayo versus Concordia University in 2016, another Supreme Court decision about a class action brought by members of employee pension plan against the university. And in this case, the Supreme Court applied what they called a liberal position, according to which grievance arbitrators have a broad exclusive jurisdiction over issues relating to the conditions of employment, provided that those conditions are shown to have an express or implicit connection to the collective agreement. And the court refused to authorize a class action in this case, because the various relevant, and there were several collective agreements relevant, they all referred to the pension plan expressly. And this was despite the fact that there were several collective agreements, several unions involved, and the majority of the unions were against this. They were in favor of a class action and expressed the concern that if each of them dealt with that separately, this will result in inconsistent arbitration awards. However, it's still interesting to see that the reaction to the impact of Weber and Perry Sound varies. In 2015, Queen's University Center for Law in Contemporary Workplace hosted a symposium in honor of the late Professor Bernie Adele to mark the 20th anniversary of Weber. And the presentations were then appeared in 2017 in a collection of essays edited by Elizabeth Chilton and Karen Schusser. So one of the presenters, Etherington, continues to be a strong critique of Weber and Perry Sound. In his view, they transformed arbitration from an alternative dispute mechanism for resolution of private dispute to a quasi-public form like courts, like labor courts, for the enforcement of not only contractual terms, but also tort and charter claims. But interestingly, a panel of arbitrators that also participate in this symposium reported that Weber has only had minimal impact on their arbitration practices. Paula Knopp, for example, noted that Weber did not represent a revolutionary change, and I quote, "Like concepts of fairness and reasonableness, which have been embraced by arbitrators over time, Weber is simply part of an evolutionary process in which arbitrators has become practical and effective form of a one-stop shop from which all parties benefit." And she also had no doubt that arbitration was well adapted to provide comprehensive dispute resolution for unionized workplaces. And similar views have been expressed by academics. Brian Langille, for example, views Weber not as a technical decision about arbitrators' exclusive jurisdiction, but rather primarily as a substantive case on the content of an employment contract, whether it's individual or collective, which may alter the normal set of rights, responsibilities, and remedies that apply between strangers. In his view, Weber simply instructs arbitrators that they are responsible for workplace disputes and when common law issues such as defamation arise that would otherwise be dealt in a civil court between two strangers would be dealt with by the arbitrator because the parties are not strangers. And another example is Karen Schusser, who takes issues with Etherington access to justice critique. In short, she argues that unions and collective bargaining are access to justice institutions offering benefits which outweigh the concern of individual access to courts. Still, there's lots of confusion in identifying the correct form, and I'm sure we'll hear about that from the other speakers, and concerns about relitigation and abusive process on the one hand, and limiting access to courts on fundamental issues on the other hand. And I think determining the nature of the dispute and the legislative intent and maintaining an appropriate balance between finality and fairness are difficult and often disputable tasks. Now, along the expansion of the scope of labor arbitration and as part of the judicial review process, courts have generally taken a very differential approach to decisions of labor arbitrators, largely because of the high degree of specialized expertise. And this has been the case prior to and following the decision in Dunsmuir in 2008. The major change was that in Dunsmuir, the three standard of review approach that was adopted in the 90s was replaced with two standards: reasonableness or correctness. And the court created some default rules for application of reasonableness, but it also added an analysis of contextual approach that depends on a number of factors, the presence and absence of privative clause, the nature of the questioning at issue, and the expertise of the tribunal. So it wasn't really clear how the defaults, together with the contextual approach, work together. And second, the court explains how the reasonableness standard will work, and it said something about that it's concerned about the existence of justification, transparency, and intelligibility within the decision-making process, but it wasn't really clear how this will work in practice. So while the aim was to provide simplicity and predictability, Dansmere and subsequent case law caused confusion and uncertainty in administrative law more broadly speaking. And so the Supreme Court in the Vavilov case attempted to fix it. And the court in Vavilov adopted a revised framework for judicial review of administrative decisions, focusing on two main questions. One, how to determine the standard of review, and two, how to conduct the review of reasonableness. On the first issue, while this was already known to some extent, the court explicitly states that there is a presumption of reasonableness that is applicable, the applicable standard whenever a court reviews an administrative decision. But the rationale of how much deference is owed shifts in a rather significant way. It is the legislator intent and the respect for institutional design made by the legislator which requires a reviewing court to adopt a posture of restraints on review. The relative expertise of the administrative decision maker, which used to be a very influential factor under the contextual approach, is no longer relevant to the determination of the standard of review. But it remains relevant to how we conduct the reasonable review, as we'll see later. So there's this presumption of reasonableness, but it can be rebutted in two situations. The first situation is where the legislator has indicated that it intends a different standard to apply, and this could occur in two situations where the legislator explicitly prescribes the applicable standard of review, or where the legislator provided a statutory appeal mechanism, thereby signaling the legislator's intent that an appellant standard of review applies, and that is the Hussein case. And this is another major change in administrative law that could be significant in our purposes, depending on the language of the legislation. Some provinces use the word judicial review, some of them use the word appeal, and this may be suggesting now that the correctness standard would apply. I'm sure Wassim will talk about that later. So that's the first situation. The second situation is that may rebut the presumption of reasonableness is where the rule of law requires the standards of correctness. And here there's three categories of legal questions. First, constitutional questions. Second, general questions of law of central importance to the legal system as a whole. This is similar to Dansmere, but not very much, because in Dansmere, it was all about questions outside the expertise of the decision maker. Here, it is not necessary to evaluate the decision maker's specialized expertise to determine that the correctness applies. And this is something that the concurring judges warn us that this category may apply very broadly, because there's lots of questions of significant importance, and we don't care anymore if it is within the scope of expertise of the decision maker or not. So this may expand decisions that are subject to correctness. And the third category is questions related to jurisdictional boundaries between two or more administrative bodies, for example, between labor arbitrators and human rights tribunals. So the two situations with the three categories replace the more relaxed contextual approach in Dansmere. So to conclude this part of the judgment, you can say that on the one hand, the presumption of reasonableness provides more consistency and predictability, and maybe, less disputes in future cases on the question of which standard applies. But the two situations with the three categories seem potentially pretty broad, significantly because of the elimination of expertise as a consideration. So we may actually see that this expands the scope of cases that are subject to correctness. Now moving to, I'm almost done. Yeah, sorry, you're on mute, I think. Alan, you're on mute.
Your time's pretty well up. 1 minute.
So I need 1 minute. Okay, no problem. Moving to the second issue, how to conduct the review of reasonableness. The court provides some very good guidelines. They say that we need to focus on the decision that was actually made by the decision maker, and we need to look at the reasons and the outcomes. Here, institutional expertise and experience of the decision maker is an important consideration, and the court describes the differential attitude that courts are expected to follow. So they don't need to, predict what the outcome is, come with open mind and look at the reasons, and they might actually, by providing respectful attention to the decision maker, realize that what sound as puzzling or counterintuitive actually makes sense when they read the decision itself. Importantly, and I'll finish with that, they explain what they meant in Dunsmuir with regards to the constellation of law and facts that the decision has to be justified by providing a long list of examples of what are the relevant elements to the decision. And some of this is well known, such as the governing statutory scheme and relevant statutory or common law and principle of statutory interpretation. But there's other elements there, such as the past practices and decisions of the administrative body and the potential impact on the decision on the individual. So we see a long list. The court says it's not a checklist, but it may open an opportunity for a more robust process of review, which may allow the court to afford less deference to arbitrators. And I'll stop here. Thank you very much.
Thank you very much, Pnina. Thank you, Professor Alon-Shenker. All right. With that, let me turn it over to Wassim Garzouzi. Wassim, is this good or bad for unions?
So I want to start from two perspectives, right? Most arbitrators say, I've never written a decision thinking about the standard of review, right? And Justice Rothstein, who used to sit on the Supreme Court and who wrote a lot of these judgments and participated in these discussions, essentially said, when I was at the Supreme Court, I would use the word reasonableness and be careful not to say incorrect or wrong and keep referring to reasonable or unreasonable, but really I would be doing a correctness review, right? And historically, unions are saying, you know, we don't want courts to intervene. We want this to be a kind of this like ecosystem where arbitrators and labor lawyers and parties are involved. And typically employers and governments say, well, maybe it's a good thing to have courts, you know, look at what's happening in the labor world. And so with that backdrop, I kind of want to discuss how the evolution from Dunsmuir to Vavilov should be impacting labor decisions specifically, right? Starting from the point of view that arbitrators don't typically think of a standard of review when they're drafting a decision, and starting from the premise that everyone tries to be reasonable at all times. So I think the starting point, let's start with Dunsmuir, because I feel like it's such a broad sweeping decision. And most people just say, well, it's reasonable. And if it's reasonable and people can read it and understand it, then typically deference will be given because labor arbitrators are experts and they're so smart and knowledgeable and they understand the parties they're dealing with, right? But when you really break down Dunsmuir,
I think you should stop there. I really like that part. I mean, let's make sure that that's highlighted in the recording.
We're done. So when you read Dunsmuir, and this was kind of supported in subsequent decisions like COSA of the Supreme Court, what they're saying is it doesn't need to be the right answer, provided that it's a possible answer, right? And that's what they literally write. They say, provided the decision falls within a range of possible acceptable outcomes. And in COSA, which was issued about a year later, the court says there might be more than one reasonable outcome. So if you're an arbitrator, this is the dream, right? Because any grievance that is argued before you could, in theory, be answered in a variety of ways, including yes or no, right? And so tremendous deference would normally be given to arbitrators, and you could write your decisions however you please, and they wouldn't be disturbed by the court. Now, we know that Justice Rothstein, who's sitting on the Supreme Court, said that's what we were kind of writing. But deep down, we were still trying to arrive at the right outcome. And I think this is where there's a bit of a clash with the standard of review. In theory, it's designed to avoid having parties litigate once they're done the arbitration, right? And so you're doing it to avoid a party spending tens of thousands of dollars and adding months, if not years, to litigation. So you're making it harder to get to the courts and for courts to review these decisions and accept them. The flip side to that is under Dunsmuir and Cosa, the examples are so extreme, and I'm going to give two examples, right? That parties are expending thousands of dollars and courts are saying, well, we don't want to intervene. And I want to talk about two examples specifically, which were issued around the same time. And one of them is Newfoundland nurses, okay? And you probably heard Newfoundland nurses. If you're an arbitrator and you were ever judicially reviewed, you were hoping, praying, and felt confident that if the respondent quoted Newfoundland nurses, you should be okay. And Newfoundland nurses was a really standard case out of Newfoundland involving vacation entitlement. And the question was, when you were a part-timer or casual employee, you received a percentage in lieu of vacation. But when you're a full-timer, it was based on your years of service. And so obviously, if you went from part-time to full-time, would you carry over your years of service or not? That was the only issue in arbitration. And the arbitrator wrote a 13-page decision, and I'm going to come back to this point, where he essentially reproduces the arguments by both sides, right? This is what the union says, years of service isn't defined or limited. The employer says, well, you don't accrue while you're a casual, therefore you shouldn't be accruing when you become full-timer. And ultimately, the arbitrator writes a 13-page decision, and in one paragraph says, when you're a casual employee, you're not accruing vacation, and therefore grievance dismissed. Doesn't really address the arguments by the parties. So the union judicially reviews the decision, and the court says, I don't really understand why he did. He essentially just said grievance denied, but doesn't explain why. And it goes to the Supreme Court, and the Supreme Court says, ultimately, right, says the labor decision was reasonable, okay? Notwithstanding that there's no explanation to understand how you arrived at that conclusion, it's reasonable because this is classic fare for arbitrators. They're not writing for the courts, they're writing for the parties, okay? And then they say, arbitration allows the parties to the agreement to resolve disputes quickly, knowing that they'll be negotiating a new collective agreement in 2 or 3 years. This process would be paralyzed if arbitrators were expected to respond to every argument or line of possible analysis, okay? So essentially they're saying, look, as long as the arbitrator decides the issue, writing for the parties, doesn't even need to explain how they arrived at that issue, that's gonna be reasonable. And this is kind of where I wanna pause here to discuss a few things, right? The starting point of that is essentially that what the court was saying to arbitrators and to the parties is on an issue like vacation, right? We don't really care. That's a small issue affecting the parties, and the court doesn't want to intervene on that issue, notwithstanding the fact that they took leave, okay? And I'm going to come back on the reasons and how addressing each argument is probably necessary now under Vavilov. But at the same time that this decision was issued, the Supreme Court intervened in another case, which was Marcotte, which was essentially whether or not individuals at the Human Rights Tribunal federally are entitled to legal costs if they're successful. And the act states the tribunal will compensate the victim for any expenses incurred by the victim as a result of the discriminatory practice. And so the only question before the tribunal was whether or not Ms. Marcotte was entitled for legal expenses under the expression expenses. And so here you have a tribunal interpreting their home statute, they're experts, and they say, yeah, what's so magical about legal expenses? They're an expense. Goes to the Supreme Court, and the Supreme Court intervenes, notwithstanding saying that it's a reasonableness standard. They intervene and they say, no, that is not a possible outcome from the word expenses. Okay, so you can see how the Supreme Court still intervened when they thought that an issue was important, and gave complete deference to arbitrators when they felt it wasn't that big of an issue. So let's flow from there now today, right? One of the, at the last NAA conference in Quebec City, Justice Gascon, who was at the Supreme Court at the time, spoke, and he said that his frustration when reading decisions is reading a 200-page decision where every single witness, right, you almost have a transcription of their testimony, and then you have every argument listed, and then you have the reasons, which are essentially 2 pages, okay? Think Newfoundland nurses. And he's saying, I don't really understand why decisions are written this way. And of course, people practicing in the federal jurisdiction know that since Jacob Finkelman was at the public board here in Ottawa, right, that was the practice. They don't have transcribers, they're not recording. And so you have a lawyer essentially taking notes as trying to stay as true as possible of what's happening in the hearing room, because there's no other way to know what actually happened. And so we still have that culture in a lot of tribunals, and including some labor arbitrators. And what Gascon was saying pre-Vavilov was that that's what was difficult for judges when reviewing a decision, okay? So let's fast forward then, we get to Vavilov. And Vavilov essentially, ideologically, right, people are thinking, okay, so if you're at the court, if you're judicially reviewing and you've got a court that's reviewing a decision, and they think it's wrong, why shouldn't they intervene, right? That's one school of thought. The other school of thought is labor arbitrators know better, and therefore we should defer to them and not let judges interfere in the process. And I want to, before we get into expertise, because I will talk about expertise briefly, it is curious that judges typically are seen as a conservative, right, entity in the process. If you look at the conservative government of Mike Harris, he appointed retired judges to hear interest arbitrations in the 90s in Ontario, or federally, the government of Stephen Harper appointed a retired judge to deal with a interest arbitration between Canada Post and Cup W. And in both instances, courts found that they lacked expertise to be doing this function. So there's real irony when you look at Vavilov from that perspective, that judges now appear to be saying, we have expertise to hear these cases. But let's pause on that thought for a minute. So with Vavilov, I think the starting point, and there's 3 things I want to stress here from Vavilov. The first is essentially the justification, okay? And the 3 points from Vavilov are justification, responsiveness, and expertise. And on the issue of justification, what that means is reasons matter, okay? So there's a recent decision by the federal court. It's Ortiz, if anyone wants the reference. It was issued about 2 months ago. But the federal court essentially says, under Dunsmuir, courts began with the outcome, and then you look back at the reasons, right? So vacation for full-timers, who cares? That sounds reasonable, right? Newfoundland nurses, we don't care if the reasons aren't that great, or even if they address every argument, right? Now, in this decision, Vavilov instructs everyone to start with the reasons and assess whether they justify the outcome, okay? So I think that's a very astute way of looking at the difference between Dunsmuir and Vavilov. So that's the starting point. You don't look at the outcome and then work your ways backwards, but you look at the reasons. The second one, and this is a point I want to emphasize for the arbitrators here, is responsiveness, okay? Reasons are the primary mechanism by which decision makers demonstrate that they have actually listened to the parties. And on this point, I want to stress this, right? When people talk about procedural fairness, for example, and we're saying, well, we're, applicants or grievers are entitled to procedural fairness, right? People think that that's for the benefit of the plaintiff or the complainant, right? But the way I've always viewed it is that's to the benefit of the decision maker. Because if you've provided robust procedural fairness to the parties, you're assured that you've had the best information to render your decision. And I feel like responsiveness is similar to that, right? When I see a decision that doesn't address the arguments made by the parties, or as Newfoundland Nurses says, you don't even have to address them in the decision, right? What you're essentially saying is, you don't need to ensure that your chain of thought is coherent, and consistent. And that's what the Supreme Court says now you have to do, right? And especially when a decision will have a harsh consequence on an affected individual, which brings it in line with Baker and procedural fairness type principles, that the more severe the outcome, the more fleshed out your decision should be, right? And so think of a termination case, for example, but think of any case. There's nothing worse for a lawyer to present 2 or 3 arguments and the arbitrator addresses one, kind of, and then issues a decision. You just feel like, well, what about the rest of it? Are you unsure? Is that why you're not writing about it? And so the Supreme Court says responsiveness to the arguments is the second critical factor. And then the third one is expertise. And Professor Alon spoke about it momentarily, but historically under Dunsmuir, arbitrators were considered experts and we would defer to their expertise. And there's several decisions, right? And we all do this, but there's several decisions where the court reviewing the decision says, well, this is Owen Scheim, for example, the GTA decision. So we're going to give deference because Owen Scheim is an expert in this field, right? Or if the case involves, you know, a member of the Ontario Labor Relations Board or the Industrial Relations Board federally, you'll hear these types of statements. And Vavilov essentially says your reasons should demonstrate that you're an expert, okay? And I'm just going to quote Justice Iacobucci, who issued a decision in the 90s on this point, and I think it's apt for our purposes. Experts in our society are called that precisely because they can arrive at well-informed and rational conclusions. If that is so, they should be able to explain to a fair-minded but less well-informed observer the reasons for their conclusions. If they cannot, they are not very expert. And I think that's what Vavilov ties together. They're saying, if you're such an expert, why are we unable to understand your decision, right? And you're saying that you're writing for the benefit of the parties, but if one party is judicially reviewing, clearly it wasn't to their benefit at that point, right? And so I think, which brings us to practical impact of this, and it's mostly a discussion point, but I remember all the way back to February, I had a case where a griever wanted to record, and an arbitrator said, no way, we're not recording these proceedings, not mediation, like the actual proceedings, right? And therefore you have 2 lawyers typing up notes, an arbitrator typing up notes, people writing by hand. And if there's a dispute about what actually happened, well, you're just relying on your notes and you're not actually sure if that actually happened in the hearing. And if the arbitrator doesn't address it in their facts, well, that's a tough issue on judicial review or at any other point. And fast forward 2 months from there, now we're all doing these Zoom hearings, right? And all of a sudden having a camera in the proceedings isn't that big of a deal because justice must go on. And so it really does raise the question of these decisions that summarize every single fact and every single testimony and every single argument, but then the reasons are inadequate. Wouldn't we all save much more time if we recorded the proceeding and then just had a decision based on the actual reasons for the outcome? So I'm just throwing that out there as something to think about, because it is nonsensical that people are taking notes, and depending on how quickly you can type, the quality of your notes are going to be better and thus give you an advantage later on in the hearing. So on that's on the judicial review and the quality of the reasons. But the other point I wanted to discuss very quickly, and Professor Alon spoke about this briefly, is when courts will look at it on a correctness standard. Now, I think actually, as Justice Rothstein admitted and acknowledged, we always do it on correctness, courts will say. And Justice Rothstein also said, discussions on standard of review are a colossal waste of time, right? However, judges do feel more comfortable intervening when there's the word appeal in a statute. And one recent example of that is a decision by the Manitoba Court of Appeal. And in that decision, the Public Utilities Board issued a decision, and the statute says when a party is appealing that decision, they go to the Court of Appeal. Historically, up until Vavilov, whenever it got to the Court of Appeal, the court would say, we're going to review this on reasonableness, tribunal, home statute, they're experts. Well, since Vavilov, because the word appeal is in the legislation, right? The Court of Appeal says, well, Vavilov tells us when there's a statutory appeal, it's a correctness standard. So you can see how that could evolve with time. You can see how the Labor Relations Act could refer to an appeal going to the divisional court. Or you can see how federally, right, the Federal Court of Appeal could deal with these issues. So it's something to think about how benign, right, or how normally you would think, well, of course, if you have an appeal, why wouldn't it be correctness? But how one word in the statute could really impact the way a court will look at things. On that note, I was going to pause here. There's another decision I wanted to discuss on exclusive jurisdiction, but I'll leave it for the end if we have time.
Okay, and I want to pose a question that came up, although it maybe was directed to you. I think maybe Richard also can take it on. And it relates to interest arbitration. And I don't know if you know, in a sense, Vavilov and Bell Canada could impact interest arbitrations as well. And they're often the nominees basically, you know, pound the chair and say, look, whatever you do, just give the outcome. The parties don't want the reasons. I mean, interest arbitration is a different animal in that sense. And I don't know if that's going to run afoul of the sort of the new direction that this has gone in. So maybe just very quickly, Wassim, and then I'll turn it to Richard and he can answer it too. Maybe Richard, why don't I let you start off with that one? Are you okay?
Yes. So it seems to me that, can you hear me? All right, am I okay, Alan? You're hearing me?
Yes.
Okay.
I unmute myself. You can hear me too.
I lack confidence in the electronics, so good. It seems to me that interest arbitration is not necessarily going to be viewed by a court. It's a different animal. If there's an understanding between the parties that they don't want any reasons, whether that applies in interest arbitration or rights, but it's more likely to apply in interest arbitration, I think there is an element of risk unless one of two things is there. The first is the relationship with the parties is so reliable that you can in fact rely on that. Or second, there needs to be some kind of written document that waives the need for reasons. I mean, this also raises the other interesting thing. Without consent, given Vavilov, and even prior to that, to what extent is it appropriate to give a bottom line decision without reasons? And that may actually be suspect and subject to review without consent. I think it's the other side of the same coin. So that's my perspective on that question. But turning to my general comments, and I realize as the last speaker, we want to leave some good time for debate. I'll try to be pretty brief. Those on the line that know me know I'm good at that occasionally. So we have in place an arbitration system that's mandated by statute and that is designed to resolve disputes arising under the four corners of collective agreements. And that has been an evolving, meandering concept or construct that has been adjusted by both legislatures and by the courts, and in two ways. One way is in defining the scope of disputes that go before arbitrators, and the other way defining the extent to which courts are permitted to intervene in what arbitrators determine. And one of the landmark cases, as we've discussed, comes out in 1995. Weber, I'm told by Justice Stephen Gouge, who acted in that case, that his name is actually Weber, but we'll call it Weber. And in that case, the court made clear that certain claims that don't expressly fall under the four corners of a collective agreement, but inferentially do, where the essential character is a workplace dispute, things such as defamation, privacy, nuisance, trespass, Charter of Rights, those things are to be dealt with in labor arbitration. Now, I come here giving my perspective on things, but obviously informed, having practiced on the management side for a few decades. and that decision historically, the employer community might have said, gee, we don't like that. We want to go to more conservative judges who are going to look at these things in a more doctrinaire way with less sort of discretionary flair. So it might be surprising to hear that I think that general approach, speaking as an employer advocate just for a moment, is the desired one. And this is the reason. There's the Wagner Act model to which the professor referred, which is the exclusive bargaining agent model that has certain twists in Canada, but similar to the North American model. And I see that as a historical quid pro quo. I mean, the Wagner Act model was imposed by legislatures, primarily to benefit workers, but also with a view to getting the economy kickstarted after the Depression. I think to the extent that employers don't want exclusive bargaining agents kicking around the workplace, to the extent that they have them, they want to be able to rely on them. And that's a critical point. Maybe we don't want to be in that system, but we're in it, let's balance it and make it work. Let's make exclusive bargaining agent status, in fact, exclusive. And so it wouldn't be, despite the alleged Weber gap, it wouldn't be in the interests of employers to have employees running off amok on their own steam, initiating legal proceedings. And when I conclude my comments in a few minutes, I'll deal with one case that I was involved in. So the Weber doctrine basically says when there's a collective agreement, you can't file a wrongful dismissal suit in the courts. And that's a threshold jurisdictional matter. I know we don't use the word jurisdiction so much anymore, but effectively that's it. Maybe the Superior Court has jurisdiction in a constitutional sense, but it's not going to exercise it. So that's consistent with what I see as the historical deal. It gives rise to the exclusive bargaining agent model. Weber is a reasoned, logical development in the law. We then get to the Perry Sound decision in 2003, and that's the decision that stands for the proposition that where a collective agreement doesn't enable probationary employees to grieve, the arbitrator nevertheless must take jurisdiction over statutory rights like employment standards and human rights. And there's logic to that as well. But imagine if I were advising a client and if my client were dealing with a union that shared the same objective, the way around that is to ensure that probationary employees aren't covered by the collective agreement. In other words, they're not in the bargaining unit until they achieve probation. And up to then, they're entitled to go to the employment standards, the Ministry of Labor, or to the courts. But that's really consistent with what happened in Weber. And then you get into these various decisions, and some of the arbitrators on this line have experienced this. The question of what happens when something like a pension plan or a travel incentive bonus isn't covered by the collective agreement, but there's some kind of practice, and there may even be documentations that explicitly stipulate that they're not covered. There's many examples. A recent-ish from 2016 is the BC Hydro decision of arbitrator Fleming, when the arbitrator held that a refusal to pay a travel incentive bonus to only certain employees was not arbitrable because it wasn't a benefit bargained for in the collective agreement. And most of the labor statutes with which we deal, the Ontario Labor Relations Act, Section 4812J, the Canada Labor Code, Section 61A1 now expressly, not inferentially, but expressly give arbitrators the right, and I would say the obligation, to apply these statutes. And then you get into interesting questions of what is an employment-related statute, and it's a pretty broad list. The list includes things like the Pension Benefits Act. There's been case law on that. Not just labor relations and employment standard statutes. And sometimes you get employers in particular arguing that even broader concepts like the Income Tax Act are employment related, and that's where you get into some interesting debates. Now, this Weber evolution applies not only to civil disputes, but also to other disputes like human rights. And as Wassim said, we may be talking about a Manitoba case that deals with that. I won't be doing that right this moment. But I want to note two interesting anomalies in the legislation, and I'm dealing with my two home jurisdictions, federal and Ontario. Section 45.1 of the Ontario Human Rights Code says the tribunal, and remember it's a tribunal, it's not a commission-based model anymore in Ontario. The tribunal may dismiss an application in whole or in part in accordance with its rules if the tribunal is of the opinion that another proceeding has appropriately dealt with the substance of the application. So it speaks in the past tense, and it says if it has dealt with it, you don't get to go and try a second kick at the can. Whereas the federal model is different. It speaks of the commission, because it's a commission-based system. The commission has to deal with the complaint unless the complaint is one that could more appropriately be dealt with initially or completely according to a procedure provided for under an act of parliament other than this act. And so that is effectively saying if it could have gone to arbitration, then maybe we're going to defer. And if your exclusive bargaining agent doesn't want to take it, take them to the CIRB on a fair representation complaint. So it's an interesting difference, a different signal by two groups of legislators. I'm not convinced that it's done with any intentionality in mind, but the outcomes are very interesting. And then as we move along the chronological spectrum, we get to the Dunsmuir case, which my colleagues have talked about in great detail. That's from 2008. And interestingly, some of you will recall that Dunsmuir was itself a labor case involving a New Brunswick government employee, where the adjudicator held that the dismissal was without cause because the employee wasn't provided, Dunsmuir wasn't provided with due process. And eventually the courts overturned the arbitrator on the basis that it was a private contract relationship and you can fire anyone with the right money. You don't need to give them a formal hearing when you're the employer. And so in that case, keep in mind that the Supreme Court of Canada and other courts actually interfered with the decision, but developed, not for the first time, there are previous decisions of the Supreme Court. We're not dealing with unreasonableness for the first time in 2008, but you'll remember that the Supreme Court went on a bit of a journey with 3 standards of review, and before that, that didn't exist. That was in the early 2000s. And so here they clarified and simplified that it's just 2 standards of review, but factors such as expertise, not to mention all the other standard factors, were taken into account. And one thing that Dunsmuir said that Vavilov continues to say is where there's a potential overlap of jurisdiction, there can be a correctness review and intervention by the courts. But the other concept on judicial review that I've always found difficult to comprehend myself is central importance to the legal system. When something's of central importance to the legal system, Dunsmuir and also Vavilov tells us that there could be a correctness standard. So what does that mean? Well, in 2011, the Supreme Court rendered its Norman decision, Norman, N-O-R--M-A-N, Regional Health Authority in Manitoba, and that concept was dealt with. And in that case, the arbitrator had used the doctrine of estoppel in arbitration, and arguably, without getting into detail, applied it in a way that a commercial court would not have applied it. And in the end, Justice Fish, speaking for the court, reversed the Court of Appeal and restored the arbitrator's decision on the basis that the application of that doctrine is not particularly a general question of law of importance to the legal system. It's unique to the labor relations regime, and arbitrators can do with it what they want. And it does raise the interesting question of if arbitrators have some of these discretionary powers or not so discretionary powers, let's just say powers like the power to import in some form or another the doctrine of estoppel, do they have the right not to apply it based perhaps on language in the collective agreement, or must they apply it? It raises that interesting question. And then we get to Vavilov, about which much has been spoken right now. And of course, the the facts of the case are interesting. It kind of reminds me of that TV show, The Americans, and you know the child of the people in question ended up getting his citizenship back. But there is an extensive discussion in that case. It's an absolutely fascinating read if you're interested in this stuff. And the court, as my colleagues have said, discounts the concept of expertise, because I think expertise is presumed, and I always wondered about that. I mentioned Mr. Justice Gouge earlier. I once mentioned to him a couple of decades ago the fact that some judges were labor lawyers and they might have more expertise on points than some inexperienced labor adjudicators. And he thought that it was more of a construct, not something that one would specifically investigate. You know, what is the CV of that arbitrator? How many arbitrations has he done? Has he ever done any arbitrations involving pensions? Well, we certainly don't want to get into that in judicial review applications with affidavits back and forth about how good the arbitrator is and whether he was in the top 10 in his LLB class back a few decades ago. So that has been dispensed with definitively. The concept of a statutory appeal mechanism is presumptively a correctness standard. But I agree with Wassim that even though the courts perhaps do protest it too much, any normal human being who has to decide if something's reasonable is first going to decide if it's correct. That's just, I think, psychology. And then they'll say, well, how correct was it? And, you know, I will say, as someone who's practiced law with clients for a number of decades, the concept of so-and-so, he or she had the right to be wrong. I have quoted that to clients from time to time, and they look at me like I'm from some Orwellian newspeak world. It makes no sense to them. And of course, as lawyers, we have to explain that to them. The other interesting thing about Vavilov is the concept of reasons. And we know they quote and approve that Newfoundland nurses decision, which says that judicial review is not a treasure hunt over the reasons of the arbitrator. But nevertheless, they make some pretty interesting observations. And I think those arbitrators on this call are going to have to be particularly cognizant of the reasons obligation. And they say the internal rationality of the decision may be called into question. This is paragraph 104. It may be called into question if the reasons exhibit clear logical fallacies, such as circular reasoning, false dilemmas, unfounded generalizations, or an absurd premise. This is not an invitation to hold administrative decision makers to the formalistic constraints and standards of academic logicians. However, a reviewing court must ultimately be satisfied that the decision maker's reasoning adds up. And so the other thing they said back at paragraph 84 is they say a principled approach to reasonableness review is one which puts those reasons first. A reviewing court must begin its inquiry into the reasonableness of decision by examining the reasons provided with respectful attention and seeking to understand the reasoning process followed by the decision maker to arrive at its conclusion. Reasonableness, according to Dunsmuir, I'm at paragraph 86, is concerned mostly with the existence of justification, transparency, and intelligibility within the decision-making process. So they're still talking about those three factors. I call it, I have trouble remembering those three, so I use the acronym TIDGE: transparency, intelligibility, and justification. Those are the three hallmarks of a decision that can be justified. So that is, there's a lot more that can be said, and my colleagues have commented on it. But when we get to this interesting question of
Richard, Richard, can you wrap 2 minutes?
Sure can. When we get to the interesting question of the borders or the jurisdiction between two tribunals, I think that can become a correctness intervention by the courts, Vavilov tells us. But also, I think that adjudicators themselves ought to apply things reasonably. And I'm going to close with an example I was involved in back in 2014. It's a reported decision. The name of the grievor is anonymized, so I'm not going to say names, but I'll say that the employer was the Toronto Sun. And there was a reporter who had legitimately injured themselves in a work-related skydiving incident a couple of decades back. So there was a legitimate hook into disability. And some employees, if I recall, were really concerned after 2 decades that this individual continued to insist on certain privileges, like not going out on gigs, keeping in the office, being allowed to get a preferential parking spot. And so they looked into it and determined that when oops, I said the gender, oh well, when she was found driving her mother to Galleria Mall in Buffalo on Boxing Day, they got suspicious. And so ultimately they terminated her employment. And the union, it was Unifor, Local 87M, in the media industry, quite rightly relied upon disability because disability was engaged. In the end, arbitrator Stout determined that she was less than upfront and upheld the discharge. But interestingly, partway through the case, this speaks well of the union, by the way, she individually went to the Human Rights Tribunal and claimed that it had to do with her ethnic background and gender, which the facts totally did not reflect. And the tribunal decided that the case was improperly brought, that it had no prospect of success, that if other human rights factors were relevant, they should have been raised at arbitration, apart from disability, and they weren't. So they kicked it out, and then arbitrator Stout, in dismissing the grievance, said, and I quote him, "I'm also of the opinion that the griever filed her human rights complaint as a hedge against losing her grievance. The griever certainly has a right to file a human rights complaint. She may have had some basis for filing a human rights complaint back in 2006. However, the griever does not have a valid complaint with respect to the events leading up to her termination. In my view, the human rights complaint demonstrates that the griever has no insight into her misconduct and is not at all sorry for the harm that she has caused." So there, the Human Rights Tribunal was sensitive, believe it or not, to the labor relations repercussions and the need for exclusivity. And the arbitrator was also sensitive to that need as well. And I would encourage adjudicators to continue on that track. And Ponak, those are my comments.
Okay, thank you very much. We have some time for questions or comments. Disguised as questions are quite okay as well. Does anyone, I'm not sure how we're going to do this. If you can raise your hand or type a question in the chat. I see Brian Keller has raised his hand. Brian, please.
Thanks, Alan. Wassim, I guess this question is directed at you, but to all the panelists. How much detail do you now have to go into, do you think, in terms of the evidence that's put before the arbitrator? If you have to give reasons, obviously, which presumably we do you have to write word for word? What do you now have to do with respect to what's been put before the arbitrator?
Right. I think, so just generally speaking, right, the general sense is you outline the major facts in the decision, and then your reasons are what matters. I think my question that I would throw to the arbitrators on this panel is, how would people feel about, even if you don't want to do video, but audio recording? And that way, if a party decides to judicially review, there's a recording that they can quote. Would people feel comfortable with that? Like, I've seen hearings where an arbitrator records the hearing, but says, this is just for me, I'm not going to disclose this, even if someone asks. I've seen arbitrators also tell parties, I don't want you to be recording. I think for me, the issue generally, when I'm reading a decision, I want to just see that the chain of thought, that every argument follows, and that if you've ruled that way, then so be it. The facts about these meaningless witnesses started working in 1988 and then progressed to somewhere else. Like, to me, like, what a waste of time for you too. Like, your time is worth something. And when I see arbitrators outlining the work history of someone, and then that evidence wasn't even relied on later, it's questionable. And the other thing I'll just say is that the longer the decision, the less accessible they are to the actual parties that we're supposed to be writing for according to the Supreme Court, right? And so for me, like, I think it's also context specific, obviously, but I would like to see someone at some point say, look, we don't all need to be taking these diligent notes because we have a recording that we'll be able to refer to later. But I know that a lot of arbitrators, and I'm not sure why, I'm not sure where this culture came from, but certainly it disappeared in the last 2 months overnight. We're all comfortable now being on camera. I think my question is, why wouldn't we do that to spare the process of writing these long decisions? So I'm throwing that out there. I don't think it needs to be overly detailed in terms of explaining what the issues are.
Any other comments?
Comment on that. As someone who gets into the courts on judicial reviews from time to time, it raises the interesting question of what is the record. And the reason arbitrators will say, look, I got this fancy little recording device, but it's just my personal notes, it's not an official record, is because his personal notes don't form part of the judicial review record. I suppose in some extraordinary case, they might on some crazy bias allegation, possibly, even then it's doubtful. But I think Wassim raises a good point in that arbitration has become so formalized. I remember as a student, Earl Palmer took me around to see some arbitrations way back in southwestern Ontario, and I don't think he hardly made a note, but he made enough notes to get the right decision in the end. It's become much, much different now. And I'll tell you, clients have commented from time to time, either at the OLRB or before arbitrators, they've said to me, do you think he or she is actually paying attention or is just writing down the words? I've had that question asked of me. And it's a question from the bleachers, from the public. And I think arbitrators have to keep that in mind. Either we deformalize, which I think there's no going back, that's not happening, but we consider ways of recording information since we're in it anyway, that allows the arbitrator to be an arbitrator and not also a court reporter. So I'm going to agree with Wassim on that.
Pnina?
Yes, thank you. I would agree. My reading of the Vavilov is actually that, there's all possible outcomes. First, the court does not really say clearly that if there's no reasons, then the decision is unreasonable. And it says that if there's no reasons, then we need to look at the records, right? And then the question is, what is the record? But reason seems to be very important in the sense that the court says that even if the outcome seems reasonable, the decision might fail because the reasons were not rational and justified and so on. So I would advise to provide reasons, and it seems to be a very, very formalistic way of providing reasons because the court lists, as I said, a long list of elements that are relevant or that the decision must be justified in relation to the constellation of laws and facts. And it includes not only the things that we believe that should be there as a governing statutory scheme or the relevant statutory or common law, but also the potential impact on the decision on the individual and past practices and decisions of the administrative bodies. So there's, for example, even though arbitrators are not bound by precedent, they will have to provide some justification when they deviate from a long standing practice or decisions. So I think reasons are important, and it at least opens the gate for the losing party to go through this list, right? And suggest that there were some fatal flaws in the decisions based on a quick discussion or a weak discussion or a lack of discussion of one of those elements in decision.
I mean, I try to write for the loser. I mean, in a sense, the loser wants to know why they lost more. And the winner is happy, but the loser really wants to know. And I think Pnina's point is a good one. Norm Jessen wanted to comment, I think, before I get back to you, Richard, if that's okay. Norm?
Yeah, hi, can you hear me?
Yep.
So just on this point about recordings, I want to say that so I was in practice until 2004, and in my time in practice, I was always amazed that whenever I was in court about how quickly things moved because a transcript was being taken and there was no need for everybody to take their own notes. And the lawyers who were used to that way of practice, they just asked questions and they moved on really quickly. So I had always thought, I don't think that transcripts are the right idea in most cases, but I do think that we should be more open to that sort of thing in particularly long and complicated hearings. I mean, obviously, when we're doing a 1 or 2 day hearing and we're trying to make it as informal as possible, they're not necessary. I don't have any problem if people want recordings and they want to have some kind of record. I think that's fine. I'm not sure that recordings in and of themselves will speed things along because people don't want to go back and look at the recordings. But in the right kind of case, I think a transcript can help move things along and keep an accurate record that everybody has. And I have always been of the view that it would be a good idea, but I think most people don't seem to agree with me, but there it is. So I just make those comments.
Okay, I'm going to turn Paula and then Kathleen. Paula, I've got
I just want to make a couple of practical points. Paula Knopf. I want to make a couple of practical points. In the States, they all have court reporters, on the whole, they have court reporters at the hearings. After the hearing is over, they take a long time to then, they don't do final submissions at the end of the hearing. They come back and do final submissions, I presume, based on the transcripts. You don't want to add that kind of cost to arbitration in Canada. I think that would be terrible. There may be cases, I agree with Norm, that are long and complicated where if the parties want to take on that cost, fair enough. But I really think we've got to do what we can to streamline arbitration, not make it more complicated. The other practical truth is that most arbitrators are old or older than many people. And the psychology of memory and the psychology of being able to give you a good decision. Studies have shown that if you write something down, you remember it better. I don't remember what I told my kids yesterday, but I remember everything I wrote down at an arbitration. That makes writing a lot easier and a lot more efficient because I've written it down, I have paid attention, and it's gone into my brain and it sticks there. So the fact that we write is very, very important. Now, as technology is changing, it may be that it becomes good enough that we will get records out of particularly our Zoom hearings, just by the technology may make transcripts cheaper and more available. But frankly, I don't want to read everything I've heard all over again after I've done the hearing. I want to sit down and write a decision. There may be points where it is necessary, but I think experience has told us that arbitrators get the facts right. It's our responsibility to make sure that you know that we've gotten the facts right or gotten the evidence right and analyzed it properly. That's our responsibility. I don't think we need technology to do that. We just need to do a good job of explaining our reasons. So that's my practical point for all of you.
Kathleen?
I'm not at all a fan of recording and for a number of reasons, all of the things that Paula and others have said. And also I think it would just be a chill on everybody in the room. You know, any spontaneity would be lessened. As to the ability to do it easily on Zoom, I'm not, unless I get a really good argument, going to be permitting a recording in Zoom. And I think many others are telling parties that they can't record with other devices. It's, you know, there's questions obviously about enforceability, but at least it's not part of the record. And if you want less intervention by the courts, don't have transcripts that people can pick over and find every little thing. I just think it's would be a terrible development if the objective is informality and less judicial intervention. That's my view.
Margot Newman, who practices both in United States and Canada and probably has had both systems with and without transcripts.
Yes, so I was going to say that the arbitration practice in the States has grown up. I mean, it's not, as Paul said, but it's not always the case now, but has grown up with court reporters. And for a number of reasons. One is that there are no similar disclosure, pre-arbitration disclosure things that happen in the United States. It's really trial by ambush, and they do post-hearing briefs. So they have transcripts for some junior to read and write a brief. They don't have to come prepared for arguing at the end of the day. They don't have Brown and Dunn, so they don't need to know what witnesses are going to say. And so it's a much more adversarial procedure, and the transcripts are not taken for the sole purpose, as I think they would be here, for appeal, to have a record for appeal. They're taken to actually navigate litigation of the arbitration when there hasn't been an exchange of information or production or that type of thing ahead of time. So when I came here and saw the system here, I'm telling you that I think that imposing transcripts, which as I understand it, would really purely be to have a record for the potential of appeal. So I agree with Kathleen. Why do you want to, leave yourself open for that? But it would totally change the way the system has evolved here. I mean, they share information. They're ready to argue at the end of the day. They have to be. There's no reason to have something read later on to write something. There are simultaneous submissions. There's no reply in the States. So it's a much different proceeding. And I do think that so much of that has evolved because of court reportings. I take my own notes as well, Paula, when I have a transcript in the States, because of the very thing that you're talking about. I'm going to know if I don't understand something because I'm writing it down or I'm listening to it. And then when I'm reviewing, I review my notes against a transcript. But it's a totally different system. And I think that you would be adding so much more of an adversarial element, which is what it is in the States if you imposed, transcripts. And I'm saying transcripts, but then we're talking about recordings. I think that if you want, and I say this to the people in the States too, doing Zoom, they say, well, let's have a recording instead of a court reporter. And I say, no, you want a recording, you want a transcript, get a court reporter. I'm not going to create the transcript. Who knows what this recording is going to be like on Zoom? Who knows if it can identify the speaker? Who knows whether it's audio or audio and video? I mean, who knows how accurate it's going to be, how blurred it's going to be, how is it going to be useful in the way that a transcript is useful if that's what you're looking for. So I've said, if you want to record, if you want a transcript, you get a court reporter. And I've had court reporters on Zoom calls making recordings, but I don't think that I think it would be a really bad thing to introduce transcriptions in Canada, because it would change the nature of the proceeding extremely.
Thank you, Margot. And court reporters are very expensive. I mean, I've had one hearing where I used it, and it was, $2,000 a day for start. Well, you've heard Richard, Wassim, Pnina, you've heard from some arbitrators. Any comments, reactions?
Can I understand every point that's been made. I think one consideration that hasn't been really discussed is the access to justice type issue, which is, I remember my first case that I ever litigated. I was like, I'd been a lawyer for about 2 months. And on the other side, there was literally a lawyer, an articling student, and a summer student. And they were all taking diligent notes of the hearing and I was alone, right, trying to take notes while I'm cross-examining, while I'm examining witnesses. And I just think without adding to the formality, you'd think that if you have a recording of what's happening in the process, right, you could refer to that at a later point, rather than when you're summarizing the argument, some side said, well, that wasn't exactly what was said, and then they read their transcript. And I would encourage you all to think of when you're in arguments, and especially when you have a party that took diligent notes or had multiple people taking notes, and then they're reading what witnesses say, whereas the other side was taking notes by hand. Like, I understand every concern that's been made, but I do think that without bringing a transcriber or adding significant cost, if someone records what's happening in the hearing for their purpose later, I think that would be an equalizer of sorts.
Richard, do you want it equalized?
Always, but it's an interesting debate, and one of the biggest obstacles to a court reporter concept, apart from the concerns expressed by, for example, Margot Newman, is the cost, and can an arbitrator force someone to pay for it? And the answer is no. Can the arbitrator permit it if one party is willing to pay for it, perhaps, but is the condition that they share it? So these are all sorts of questions that continue, but I do reiterate my concern about the perception that some adjudicators are more focused on getting down all the words than absorbing the concepts. And that's not just one client that said that to me. I did want to comment on one other thing from earlier, which is Vavilov. And I think if there's anything to be taken by arbitrators from it, it's this. You don't have to follow, stare decisis continues not to apply, but the court made very clear that it's important for arbitrators and other decision makers to explain why they're deviating. And it may be compelling public policy, it may be the facts of the case, it may be the workplace relationship, it could be anything, but that has to be expressed. And I think a tenuous and disingenuous attempt to distinguish a case that adjudicators worldwide sometimes try to do is not going to be given the same lenience as before. So that's a different point, but I wanted to make that point, Alan.
Thank you. Bill Marcotte, Bill? Whoops, hang on, sorry, you're muted. That was my mistake.
Okay.
Yeah.
Two very minor points. One of the reasons why I take notes, and as soon as someone starts speaking, I start writing. And I learned that in postgraduate school. And why was I doing that? Because if I didn't start writing when someone started speaking, my mind would wander and I'd get bored. So by writing down everything someone's saying, I'm completely focused on what's going on. So that's why I do it. And then secondly, this is a comment directed to Richard. I keep in mind the acronym JET. It's easier to say than TIDGE.
Okay, all right. Fair point.
All right. Brian Keller. Hang on, why is it not? There we go.
Just to Rick's point, I do not take verbatim notes because typically in an arbitration, I know what I'm looking for. And I don't feel that my role is that to emulate a court reporter. So just as some arbitrators, or just as some of Rick's client may say, is the arbitrator paying attention because all they seem to be doing is writing? I've been criticized at times for not writing. And a counsel has approached me and said, my client is concerned that you're not writing enough down. So how do you balance that, Rick?
Well, I guess there's a writing equilibrium point. I don't know what it is, but I will say that sometimes when an arbitrator's, and I'm just, I might be contradicting myself, but I'm not on a paid gig today, so I'll just tell you what I'm thinking. That an arbitrator, if one party's making an argument and it's written down, the other party's making an argument, there's a whole 5 or 10 minutes where nothing's written down. There's a perception in human psychology that argument's not being taken seriously or given much weight. I think that's the concern when arguments are made. I've heard that point too, admittedly, to be frank with you. but there has to be an equilibrium point. But I hear what Brian's saying, which is that if you're not writing something down, someone's going to get offended or feel that justice isn't being served. But there's got to be a good equilibrium point. When arbitrators or vice chairs or whatever tribunal we're talking about say, hold on, what was that word? That's when people start to get concerned.
I've got just a quick question. You know, in terms of dealing and coming back to Vavilov and dealing with all the arguments, not all the arguments are good arguments. And, you know, I may simply list the arguments, but then focus on the 2 or 3 that I think are really going to, excuse me, are going to decide the case. And I mean, do you want me to say, for example, that was a dumb argument and, you know, and I'm going to ignore it? I suppose I could say that a little bit more judiciously, but there are some arguments that, you know, don't add much. And I'd hate to think that I would, you know, sort of run the risk of being overturned simply because I'm, you know, I didn't want to say, gee, that was, you know, that argument wasn't helpful and I'm going to ignore it.
Right.
Because the parties have to work together as well.
Yeah, I guess my general sense is you don't need to elaborate that much, but I think it's like when the Supreme Court says you don't need to address the argument or any argument, like Newfoundland nurses, I think it's almost like, but what else are you doing, right? Like what is your role as an arbitrator? And so there's a lot of validity in addressing an argument, I think. Like, I know some arbitrators, I don't want to address an argument because it might be bad news for the party making it. But like you hedge that in a variety of ways. To me, it's like it brings clarity to the parties. So many times after an award is issued, how many times do the parties come back for clarification? And I think that's a deficiency of reasons. There's a reason why parties so often come back after an award is issued. The other thing is I think it allows
Never in my
people,
decisions.
and then I also think the other benefit is it allows we are relying on arbitral awards constantly, and constantly when an argument is not addressed by an arbitrator, I do this, I'm sure Richard does the same, you'll say, yeah, but the arbitrator didn't address this argument. So you're relitigating issues unnecessarily as well. Not to mention, it gives confidence to the parties that you've turned your mind to every argument and you've arrived at that decision. That would be what I would respond to that.
Okay, we're running out of time and we're running into another session. Pnina, did you have your hand up? Did you want to say something quickly? And then I'm going to thank everyone.
Thank you. Very quickly, the losing party can say, yes, the Supreme Court in Vavilov listed not only the evidence before the decision maker as a relevant element, but also the submissions of the parties. So the answer to your question is yes, you do need to take into account the arguments that were made by the parties because a losing party can use that for judicial review. And my second very quick comment is with regards to recording. I am all in favor of taking notes, and I'm very suspicious of recording. It reminds me sports events and a referee going back to the screen and reviewing what just happened. I think if we want to maintain an informal process, it will be better without a recording, at least not a Zoom recording.
Thank you. And with that, I want to thank Pnina, Richard, Wassim, for your preparation, for taking the time to think about the issues and having a presentation that I think was enjoyed by everyone. We've got, this is a Saturday morning in summer, and we had, I think, almost 40 people at the height of this session. So thank you everyone for turning out. And thank you, Tasneem, for your facilitation. This was very smooth, and I'm just delighted how well this worked out. So thank you, everybody, and applause to the speakers and to the audience. And looking forward to seeing everybody in a non-virtual way once we're allowed to do that. So take care, everyone. Have a great weekend and enjoy this coming week with Canada Day. Okay, bye-bye.